Hi, I'm Gloria Boykins. This is my Teach Back presentation for POA's 2041. How do cases move through the federal judiciary system? To start the case off, we always have a pleading, and a pleading is a formal statement of the cause of an action or defense. Next, there's a pretrial. A pretrial hearing is a meeting that occurs before trial action begins. These are generally attended by the plaintiff, defendant, the judge, the lawyers, and sometimes other parties. Pretrial hearings aim to resolve some of the legal issues before the trial begins. Now, we have the pretrial conferences, right? And in most civil cases, the judge holds these on issues that can be decided before the trial. The lawyers and judge agree before trial what issues are in dispute. Then both sides reveal whom they intend to call as witness and what evidence they will introduce at trial. There's a discovery process after that, and it's during the discovery that the lawyers try to develop evidence for their case. They learn about their opponent's case, they ask to inspect documents, they interview people who know something about what happened. So basically, they're gathering the information they'll need to move their case forward. Then there's the motions. Attorneys use motions to request that the court take a specific action. Settlement efforts and alternative dispute resolution. Sometimes in the course of a pretrial conference, it becomes clear that the best outcome for both parties is to settle the civil case instead of going ahead with the trial. In fact, fewer than 1 out of 20 cases ever goes to trial. 1 out of 20, okay? That's like 5% of cases go to trial. So the OJ case must have been huge because that went to trial. Now, here's how the trial system works. You have the jury trials, there are bench trials, opening statements, presentation of evidence, closing arguments, instruction and standard of proof, deliberations and verdict. Post-trial is the judgment and right to appeal. Now I'll explain each of these and how it moves through the judicial court system. What's a jury trial? That's the first thing you want to know. What is it? You know, you hear people all the time, I have jury duty, and most Americans hate going to jury duty. So in a jury trial, it is a jury's job to decide what happened and to apply the legal standards the judge tells them to apply to reach a verdict. The plaintiff presents evidence supporting its view of the case, and the defendant presents evidence rebutting the plaintiff's evidence or supporting its own view of the case. From these presentations, the jury must decide what actually happened and apply the law to those facts. So a jury trial is like what you see in all those court shows, like Matlock back in the day. You have 12 jury. It was a great book, 12 Angry Men, written about that. And basically they decide whether or not the defendant is guilty or innocent just by the evidence that's brought before the court. And so they get to decide, and it's supposed to be a jury of your peers. But then again, if I'm not rich, I really don't see a bunch of poor people trying to help me decide my fate. So hey, but that's a whole nother story. What are bench trials? Well, if the parties agree not to have a jury trial and to leave the fact finding to the judge, then the trial is called a bench trial. Meaning your peers are not there. It's just you and the judge, okay, and the attorneys. So it's basically closed off to people. In either kind of trial, the judge makes sure the correct legal standards are followed. In contrast to a jury trial, in a bench trial, the judge decides the facts and renders the verdict. So in other words, you're basically pleading to the judge, not to 12 people of your peers in a bench trial. Now, before you can have a jury trial, you really need to have jury selection. And a jury trial begins with the selection of the jurors. Citizens are selected for jury service through a process that is set out in laws passed by Congress and in the Federal Rules of Procedure. First, citizens are called to court to be available to serve on juries. These citizens are selected at random from source lists. In most district lists of registered or actual voters, which may be augmented by other sources, such as lists of licensed drivers in the judicial district. The judge and the lawyers in each case then choose the persons who will actually serve on the jury. So after they have their jurors, they select their 12 people. Now they're actually ready to give their opening statements. And it is what it says. It's clear and simple. Opening statement is a statement to open, right? Once a jury has been selected, the lawyers for both sides give their opening statements. The purpose of the opening statement is to allow each side to give the jury an overview of the evidence it will present. Now, the presentation of evidence. The lawyers start to introduce the evidence after the opening statement. The evidence the jury or judge in a bench trial relies on to decide the case consists of two types. Physical evidence, such as documents, photographs, and objects, also called exhibits, and two, the testimony of witnesses who are questioned by the lawyers. Evidence ruling. The presentation of evidence is subject to rules that are designed to ensure that only reliable and relevant evidence is admitted. So in other words, you can't just bring in anything and put in and say, okay, well, this is evidence. It has to prove that it can really give true support to the case. Okay, if it's a murder trial and the weapon is a gun, you can bring the gun as evidence, but it can't be a murder trial. We know that the victim died from a gunshot wound, and you're going to bring in a wine bottle and say this is the murder weapon. No, okay? After all that, after the evidence has been presented, the lawyers for each party make their closing arguments to the jury. The closing arguments finish the presentation of their cases. Closing arguments review the most important features of each side case. But like opening statements, they are not, I repeat, not evidence themselves. Okay? So when I think of a closing argument, I'm thinking of more of the summation. The lawyer gets there and basically he's saying, you need to find my client not guilty because of, what's been proven here, basically. Instruction and standard of proof. Now that's the next step. Okay, following the closing argument, the judge gives instruction to the jury explaining the relevant law, how the law applies to the case being tried, and what questions the jury must decide. So this is where precedent come in. The judge will say, okay, well, this is the law that apply. This is the law set forth by whatever, and you need to do this. So he's basically giving them instruction and letting them know how to go about doing so. You have the deliberation and verdict. So the jury retires to the jury room to discuss the evidence and to reach a verdict. In civil cases, all the jurors must agree on the verdict unless the parties have told the judge before the trial that they will accept a non-unanimous verdict. Okay? So that's when they go in the room and they say, well, you know what, he's innocent because such and such. It's obvious that he died from a gunshot wound, but she hit him with a wine bottle. So the wine bottle is not what killed him. So, something like that. And go from there. I'll watch Matlock. Here's the judgment. In civil cases, if the jury or judge decides in favor of the plaintiff, the result usually is that the defendant must pay the plaintiff money or damages. The judge orders the defendant to pay the decided amount. Sometimes the defendant is ordered to take some specific action that will restore the plaintiff's rights. If the defendant wins the case, however, there is nothing more the trial needs to do. Now, after all this, the defendant have a right to appeal. He might not like the verdict, right? You found me guilty, but I know I'm innocent, so we're going to appeal it. And so the losing party in a federal civil case has a right to appeal the case to the U.S. Court of Appeals. That is, ask the Court of Appeal to review the case and determine whether the trial was conducted properly. It could be something as simple as he feel like he got shifted. I didn't get a fair trial because juror number 7 was married to the whatever. That wouldn't have happened. Well, it's not supposed to happen, but who knows? So this is my presentation. This information I gathered here, I use how cases move through the federal court system. And I also use What to Expect at a Pretrial Hearing by Jose Rivera, and I got it from Legal Match. Thank you. This is Gloria Boykin signing off.